Last not the least, Adebisi Lamide. Round of applause for her, please.
Sure.
Good morning, everyone. Good morning, everyone. I trust that we've all been enjoying the NBA-SBL so far. So the aim of this session is essentially to give us a recap of what we had yesterday and kind of highlight some takeaways from the sessions and also look at it from the perspective of younger lawyers. So yesterday we had about 5 insightful sessions which covered the African Continental Free Trade Agreement, ESG issues, CAMA 2020, Ponzi schemes, and in-house and external counsel relationship. So our interviewees today will be answering some questions that would sort of give us, like I said, a recap. So I'll start with Mr. Rashid on ESG issues, right? So from the ESG session yesterday, we learned that MSMEs and the informal sector, they have a very huge part to play in the Nigerian economy, and they will also require special innovation to carry them along. And also, we also saw that over time, we had put conversations on social and governance at the back burner and mainly focused on environmental issues. So could you please tell us in a nutshell, what is ESG and how do you see this affecting businesses in the energy sector?
Thank you. So ESG, in a nutshell, is essentially a way of evaluating the extent of work done by a company towards achieving its social goals. The E stands for environmental, the S social, and G is governance. So under these 3 broad heads, you have some sub-themes. So you're looking at things like recycling, waste management, reduction of carbon emissions for environment. Social, you're looking at issues around diversity, gender equality, consumer protection, data privacy, labor standards. And for governance, you're looking at general policies within an organization. So issues around anti-bribery policies, whistleblower schemes, executive compensation. So as we see it in the energy sector, ESG has definitely come to stay. As we know, a lot of the energy companies are under a lot of pressure to reduce their carbon emissions and meet the net zero commitments. So we're seeing, a lot of companies sort of invest more in cleaner energy infrastructure.
Yeah.
And if we also look at legislation, the recently passed PIA sort of gives, legislative backing to some of these issues.
Yeah.
So it's, sorry. So issues around host community trusts, which comes under social, as well as an environmental remediation fund for the environment. So we see it, playing a key factor.
Rashid. So thank you so much, Rashid, for that brief recap. One of the conversations that we had yesterday was around CAMA 2020, right? So, we heard yesterday that there were about 200 changes made to CAMA, and we discussed extensively on creating an option for filing of transfer of shares and also the importance of understanding your client's business structure in order to have the client's business in order to advise on the appropriate structure. So at DVC, could you please give us 1 or 2 key takeaways from that discussion in 1 second?
All right, thank you very much for that. All right, thank you very much for that. So yesterday we went through the CAMA and we looked at some of the innovations and then the challenges of implementing the provisions of CAMA. And I think I won't belabor the points on the innovations. I'll simply be talking about some of the challenges faced with implementing the innovations of CAMA, which is basically converting from analog to the digital aspect of filing processes with the Corporate Affairs Commission. And one of the important points that was stressed yesterday was the fact that CAC doesn't issue CTCs again. Rather, we have certified extracts, and the certified extract that we get from CACs are either inaccurate or incomplete. You have the details of the shareholders missing, and then we advise CAC to find a way of making sure that the extracts we get are accurate and up to date. Another important point is the fact that CAC doesn't accept share transfer any longer. And you know that when you're doing M&A transactions or transactions with bank, they typically request for updated, up-to-date CAC2A and all that. And we asked the commission to consider maybe an optional filing. It's not compulsory, but if you need to file with CAC just for record purposes, you should be able to do that. Thank you.
Thank you so much, Adebisi. So one of the other interesting sessions was Ponzi schemes and insolvency. You know, in Nigeria today, we see that there's a high prevalence of Ponzi schemes due to various reasons. Charles, do you think that the activities of these schemes can be curtailed, and what role does insolvency play?
Thank you, Lolia. I fully agree that there's a prevalence of Ponzi schemes in the country currently. I know a few people that have lost money to these schemes, and on a regular day, I'm in court trying to help investors recover their funds from promoters of these companies that have disappeared into thin air. Yeah, considering the economic downturn in the country, it is not surprising that people are turning to these unlicensed, unregistered schemes that are promising them unrealistic return on investment, and then you see the promoters disappear into thin air after a short while. I think that it can be curtailed, and from this plenary yesterday, it was obvious that a combination of two approaches, one, the preventive approach that deals majorly with awareness and sensitization. A lot of people should be made to realize the red flags. When you see these companies promising you 15%, 25% ROI, they are not registered, they are not licensed, they are unregulated, you should, take a cue from that and know not to put your money there. But this sensitization should not just be limited to the urban areas. There are a lot of people in the villages, the settlement, that are being exploited, and then these schemes are taking their money. And then the other part is actually the recovery aspect, and that is why I think insolvency comes in. Because once the bubble bursts and these investors disappear, a lot of the promoters rather, the investors are left to look for how to recover their funds. Some of them go to court, some of them use the police and EFCC as debt recovery agents, and then that is where insolvency can actually help. An insolvency practitioner under the insolvency regulation, can liquidate the company, can help to claw back part of the resources, and then distribute the assets recovered among the investors. So I think a combination of those two approaches can help. And yesterday at the session,
thank you so much, Charles, for that answer. I think as we round up, we had a very interesting conversation, on the relationship between and the expectations of in-house counsel and external counsel. As young lawyers, I would just like each one of you to, in a few sentences, right, highlight, the key things you took away from that conversation. Personally, I took away that we should embrace innovation, and it's a prerequisite for progress. So I guess I'll just start from Rashid.
Okay, so I think, the fundamental thing is to understand that the clients, at least in our markets, are very sophisticated. And so they're looking for, very bespoke advice. They don't need you to regurgitate the law, but, to see that you've thought through the issues and how it affects their business.
Thank you. And you, Charles?
Yeah, well, technology. Everybody needs to embrace technology. The good thing about it is, as a young lawyer, you are, technologically driven. And if you look at the crop of people that are going in-house now, 4 to 8 years post-call experience, they are actually young lawyers too. So young lawyers external counsel can relate with young lawyers in-house, and they can drive the process. So sometimes the old folks need to take a step back, allow the young people drive the process, because they speak the language of their counterparts that are in-house. So I think if you do that, you see more progress.
Yeah, for me, two things. For senior lawyers, you should get feedback from clients that use service. And then for junior lawyers, you should always take ownership of work that you are being assigned. It is very important.
So thank you so very much, and that brings us to the end of our session.
Round of applause. Can we have a quick photo up with the interviewees and anchor, please? If we can have the photographer quickly. Also like to thank our sponsors again, Stream Sowers and Cone, the Law Crest LLP, and Grey Chapel Legal. If you can join us for pictures also, we would appreciate that. Any reps of the sponsors, please. Thank you. A few pictures with the sponsors. Thank you. Another round of applause, please. Very apt and concise review of what happened yesterday. And in case you missed that, you have your update. So we're moving on very quickly to plenary 7. Once again, to remind everybody here and those online that you can access all of this information on the Hoover app. Hoover is H-O-V-A. You can download that on the Play Store or the Apple Store. Click on the agenda and go to the particular plenary session, and all the information can be accessed. So we're moving on to tax administration strides and the Nigerian business environment. This particular session is sponsored by Udo Odoma and Bello Osage and the Nigerian Sovereign Investment Authority. A round of applause for our sponsors, please. I would like to now introduce the moderator. This is Mrs. Lolade Ososami, a partner with Udo Odoma and Bello Osage. A round of applause for her, please. All the profiles of the moderator and our speakers can be found on the Hoover app. I'd like to introduce our first panelist, Mr. Mohammed Maman Nami, the chairman of the Federal Inland Revenue Service, who's ably represented by Mr. Uru Okpai, Director, Technical Services Department, FIRS. A round of applause for him, please. Thank you so much, sir. You have to join us on stage, sir. Thank you. Moving on, I'd like to also introduce Mr. Taiwo Oyedele, Africa Tax and Legal Services Leader, PwC Nigeria. A round of applause. Warm welcome for the partner of Lilo Legal, Mr. Folabi Elebiju. A round of applause for him, please. I'd like to introduce Dr. Jude Odinkonigbo, Counsel Templars. A round of applause for him, please. And the final panelist is Mrs. Titi Akinlawo, Senior Advocate of Nigeria, Principal Partner Akinlawo and Ajomo. A round of applause for her, please. True life story. When I got back to Lagos after my youth service, that was the first law firm I worked in. So thank you, ma'am, and I'm a proud advocate of that law firm.
Good morning, ladies and gentlemen. Welcome to this plenary session on taxation, a topic that increasingly is becoming a topic of interest to every Nigerian, and rightly so, because we are all stakeholders when it comes to the issue of taxation. This morning, we're talking about tax administration strides and the Nigerian business environment. I'd like to start by saying that tax is a convergence of policy, law, and economics. And so any panel that would do justice to a subject on taxation must represent each of these disciplines. And so this morning, we're going to be talking about tax, which is also primarily a tool for revenue generation for the provision of public services. And more importantly, a tool to create an enabling business environment, because without healthy businesses, you cannot generate revenue. And to create that enabling environment, you need an efficient tax administrative system, which is why this morning we're looking at our tax administration and how it has evolved, the progress that has been made, the challenges, and how we can find a way forward in tackling those. So this morning, to set the tone for us, is Mr. Taiwo Oyedele, our leader, Africa Tax Policy from PwC. He's going to set the tone by presenting a discourse on taxation from the context of the current economic situation, fiscal measures, and the tax implications. Taiwo, please, I hand over to you.
Thank you. Do I need to use both?
If you're comfortable, you can.
Good morning, everyone, and it's a pleasure to be here. I have only 10 minutes, so I will stand on existing protocols. I'm going to be speaking to us on the subject of tax administration, the business environment within the context of our economic realities. And let me just ask you a simple question, actually. How many of us in this hall are happy to pay our taxes? Okay, so that's about 5%. How many of us think we should be paying our taxes? Okay, almost 60%. So the reality is, I don't know of anyone who is so excited to pay their taxes, even in countries where things work. But we do acknowledge and recognize that it's necessary for us to have a society. The people of Sri Lanka can tell you a lot more about that. So my presentation has 4 main segments in 10 minutes: the economic context, the business environment, tax administration and some recent changes, then contentious issues and the way forward. So the economy is not doing well. I'm just telling you what everybody knows already. And it seems to get worse every day. So I'm feeling more concerned today than I was this time yesterday. Before the news that says we're going to be spending 6.7 trillion naira on subsidy next year. And part of the news also is that in the first 4 months of this year, we spent all the revenue that the federal government collected just to service debt, and it wasn't enough. So we also borrowed to add on top of it. Debt service cost to revenue ratio was 119%. If that doesn't give you any concern, then we need to interrogate whether you are truly Nigerian. Now, these things are coming all together at the same time. Revenue issues, debt issues, spending problems with insecurity. The most important ones from the business environment perspective are issues to do with inflation, issues to do with unemployment, and foreign exchange. So those tripod, for me, if we can address it, you see a significant shift from where we are now to where we need to be, given that issues of infrastructure will take time for you to address. Our debt is now growing faster than our GDP, and the cost of servicing our debt is growing faster than our revenue. We need to reverse that trend if we must have a country. The business environment is also a subset of the economy. And we have issues to do with regulations, or maybe I should say over-regulation, by all manners of government agencies. Many of them seem to be very excited to find you doing the wrong thing so they can impose fines, rather than supporting you to do the right thing and facilitate your business, which is what the economy needs. This is particularly so, or maybe worse, for SMEs, because they usually don't have the resources. Sometimes they don't even have the knowledge to know what they need to do. Next thing about the business environment is policies. And I always say that policies is one area where government can achieve a lot without spending anything. Literally, it doesn't have to cost you money. You don't need to budget for it. Policies are those decisions you make about how to run your economy so that you get the best outcome for every little effort that we put into it. And also there's taxation, which is one of the main focus of this session. So we have all manners of taxes. As if that is not enough, in the past 2-3 years alone, we have introduced about 4 to 5 different taxes on companies alone, including those on their income. And we also have increased the rate of so many taxes that businesses and individuals have to pay. This is in addition to the informal taxes that are not legislated by any law, but people are having to pay, sometimes to non-state actors, as well as implicit taxes, when you have to spend your money to do that which government should be doing for you. And I'm sure everybody here can relate to that. So what are the issues around tax administration and the recent changes in the law? The Finance Act 2021, being the latest in the series of those amendments, have a number of interesting provisions. Maybe I'll speak to just 1 or 2 of them. For example, there is one that introduced the police trust fund levy. Government says police needs some funding, and I'm sure nobody will debate that. What we are not sure about is why should you come to us for the money? The reason why we pay personal income tax, company income tax, VAT, is so that government can collect it and allocate as the need may arise. So you cannot keep coming back to us every single time you say science and engineering is an area we need to focus on, Nigerians pay another tax. The same thing we did in 1993, we said education needs some special focus. We introduced education tax. Fast forward to 2022, they have been on strike now for 5 months and counting. The question is, if we think that every problem you have is a problem of more money, you will never get the solutions you're looking for. You cannot fix the problem of a basket that cannot hold water by increasing the intensity with which you pour water into the basket. Then we have other amendments, like removing the exemption for educational institutions. They need to pay taxes. I'm still trying to reconcile that in a situation where we think education is important. FRS also has more powers to use technology to connect to taxpayer system for tax administration and to collect information, as well as the FRS being the sole or the primary tax agency at the federal level. We also have more taxes, like I said, including a recently passed bill at the National Assembly seeking to impose a levy for NYSC. They say NYSC is important, let's fund it. Another tax on businesses. And I keep asking myself, when will this stop? I wonder if there's anyone who is trying to add up these percentages, whether it has exceeded 100, right? 30% of profit for this, 2% of this. If you add up, once it reaches close to 100%, then there's no point doing business anymore, right? We all just stop and start praying to God. We have the FRS recently saying that people should submit certificate of acceptance from the Industrial Inspectorate Division before they can claim capital allowances. And government saying we need to come back to VAT. Some people are not paying the right amount of taxes. We also have issues to do with VAT exemption, not covering diesel anymore. So based on the VAT exemption, modification order 2021, there's VAT on diesel. And if you export, non-oil export is no longer zero rated. Usually when you want to promote exports, you zero rate your export so that when it gets to the other country, it can be competitive. Nigeria did the exact opposite. The same country where they said we need to promote non-oil export. I can't reconcile it. Then we have some important decided cases, including the one that says you cannot amend the law and apply it retrospectively. I think lawyers always remind us about this every time. And then some saying you have to pay some deposit before you can appeal your case with the government. I'll move on quickly to what are the contentious issues, and then I'll wrap up. I think my 10 minutes is almost up. Number one is, just yesterday again, the National Assembly passed for second reading. I think that means it's going to committees, right? A bill to establish a tax crimes commission, and there will be an inspector general for tax matters to start prosecuting tax evaders. And I said, well, when I read the bill, I can't stop laughing. It's either whoever put up the bill did not understand what they were doing, or they have something else in mind that they're not telling us, because they're going to create another agency, appoint all manners of people, chasing people up and down all over the place. These roles already reside with the FRS. We support from the EFCC and the ICPC. Most times what we need in Nigeria is not more laws, is to implement that which we already have. Then we have the tax administration's approach to assessment and collection and administration. And we've seen some, impressive development, like Kaduna State did some reforms. They increased their tax revenue by 300% in less than 5 years. Impressive. On those states, by just cutting out, politicians and consultants, they increased their revenue by more than 200%. We see Anambra State trying to assess taxes to individuals by sending them SMSs on their mobile phones. FRS is leading the pack, has introduced a lot of technological innovations, including tax promas. But there's a question about tax promas. The law says I should self-assess myself, right? But if you go to tax promas, it tells you how much you must pay. So the question is, am I losing that right that I have under the law to do my self-assessment? These are some of the issues that the panelists, their lawyers, I'm not, will be able to help us with. So in closing, what's the way forward? We need to have meaningful engagement, collaboration, and ensure that we do everything, putting the interests of our country first, over and above the interests of our various silos in which we operate from. And this would include an inclusive approach to lawmaking and policies, data and evidence for making decisions, continuous engagement, transparent and honest communication with the people, then monitoring and feedback to review whenever it becomes necessary. So I'll close with this quote by Lowell Nosban. And he said, a fine is a tax for doing something wrong. A tax is a fine for doing something right. Whether you do something right or something wrong, you have to pay to government. Thank you very much.
Thank you for that presentation. Can we hear me? Okay, yes. Yes. So we're just going to quickly run through our script this morning and then go off script, because as much as possible, I would like us to have some meaningful conversations here this morning. It's not every time that we're privileged to have the tax authorities represented here, a seasoned tax economist who is also involved in tax policy making, and erudite tax lawyers in the same room. So before we get to that aspect of our panel discussions this morning, first of all, I'd like us to take some of the contentious issues that Taiwo has highlighted during his presentation. I know that we're lawyers and we're in the business of dispute resolution and advocacy. And so this morning, I'd like to direct my first issue for discussion to Mrs. Titi Lola Akinlawo, Senior Advocate of Nigeria, by asking her to comment on her experience and her thoughts on the tax appeals process as has been affected by the new rules that have been passed within 2021 to date. Mrs. Akinlao, please comment on the Federal High Court procedural rules and TAT procedural rules. Thank you. You need to press the button.
Okay. Thank you, Madam Moderator. My experience in the law courts with the Tax Appeal Tribunal rules, the most germane issue there is that before you are to file a petition or an appeal before the courts, you have to deposit 50% of the amount charged or to be paid by the company. And in such a situation, you find out that if a company is charged like 3-4 million naira as assessable tax, and you are asked to deposit 50% of it before you can appeal to contend against such an assessment, one wonders how the company is expected to survive. If you pay so much deposit into the tribunal or even the Federal High Court, whichever one is applicable, and after the tribunal, and you still want to go to the Federal High Court to appeal, there you are expected to deposit the total amount of the decision of the tribunal. That is, in the case of assessment of 4 million, the tribunal finds that you are liable to pay 4 million. Then the Federal High Court, before your appeal can be taken, expects that that total sum of 4 million must be deposited, must be given to the registrar of the chief registrar of the Federal High Court to put in an interest-ridden account. And then the question is, how will that help the company to generate more revenue, to be able to produce more and be able to pay more tax? So it's like you're drawing the company back. The company is not very likely to want to pay, and even if it's like able to pay, it's going to affect its cash flow, no doubt. So in such a situation, I would want to suggest that as against depositing money, why can't they do performance bond, as done in the construction industry? Why would they have to put their cash flow in jeopardy just to be able to satisfy the government to pay tax? And then you find out that even if at the end of the day, if their appeal succeeds, it's not as if the FIRS will refund the money plus the interest. They will say, okay, we'll give you a credit for another tax to be paid. So you don't ever get the money back. So we should, I think, move away from this and try to find another way of ensuring that appellants prosecute their appeal, because the whole essence of the deposit is to ensure that they prosecute the appeal, whichever way. And if we can secure another method to ensure prosecuting the appeal, I think it would be better rather than putting the cash flow of companies or taxpayers in jeopardy.
Thank you very much, Mrs. Akinlao. Mr. Opai, you will have your session in a bit, but please, I would like you to note this particular issue because it's important. As Mrs. Akinlao has said, we need to connect the dots. If we're looking at taxation as a tool to create an enabling environment, then we must make sure that companies at least are not deprived the opportunity of having sufficient cash flow to run their businesses whilst they're still trying to resolve a dispute with the tax authorities. Thankfully, the Tax Appeals Tribunal, at least I know that 2 tax appeal tribunals have ruled in favor of the taxpayer on that issue of the need to deposit 50% before your matter can be heard. And so again, that's very encouraging. It shows that people are thinking about these issues, and at least those that are administering tax justice are mindful of these challenges and are addressing them. But I think it would be better for us to go back and amend those rules along the lines of what Mrs. Akinlawon has suggested. Now, moving on to the issue of tax certainty, which is also very important because statistics have shown that taxpayers actually are more interested in tax certainty rather than tax avoidance. There is this perception that businesses would do anything and everything to avoid paying taxes. That is not entirely correct. A lot of businesses with integrity are happy to pay their taxes in the hope that those taxes will be administered to provide basic amenities such as power and the infrastructure that they need to advance their businesses. And so businesses are really not in the business of avoiding tax, but they want certainty. They want clarity so that they're able to plan. As they strategize, they're able to plan how much would likely go into taxes in any given financial year. So, Mr. Lebiju, I'm going to ask you this morning, we're talking about tax administration strides. What are your views on whether the current tax administrative strides have achieved greater tax certainty in Nigeria?
Thank you. Thank you, Madam Moderator. Good morning, everyone. It's a pleasure to be here. Good afternoon. That question. Thank you, Madam Moderator. Good afternoon, everyone. It's a pleasure to be here. It's interesting that we're actually talking about tax certainty at this time, because if I want to pick, for example, the Companies Income Tax Act, the only time that whole body of law was in one document was in 2004, or when the 2004 laws of the Federation was consolidated. Thereafter, quite a number of amendments have been made, and starting with the major amendment in 2007, and of course, we've had the Finance Act 2019, 2020, and 2021. So as of today, for example, if somebody wants to understand what are my responsibilities, a company wants to understand what are my responsibilities under the Companies Income Tax Act, he has to go and be piecing together a panoply of documents, and that does not help with certainty. I just wanted to make that point at the very beginning, that right now, whether it's the FRS, whether it's the Law Reform Commission, JTB, because I know, for example, that there is the FRS Compendium of Tax Laws, but that was based on the 2004 laws, 2004, 2007 era. And since then, every time the laws have been amended, taxpayers are left to their own devices to find out, where what is. And I'll give an example. Section 13 of the Companies Income Tax Act, which relates to rules on permanent establishment, has been amended twice, in 2019, 2020, and 2021. So we could, for instance, have actually been, the 2021 amendments could have been what was done in 2019. And then we could have cut out all those other ones. Because as at 2019, all the issues about digital taxation that 2021 was trying to capture were already in existence. All those issues were already in existence. So that's about that. The other thing I want to say actually is that the fact that we're talking about tax certainty, in a sense, is actually a credit, is a positive to the administration to the present administration. Why do I say so? Since maybe between 2007, between 2007 and 2019, there wasn't anything. There wasn't much, let me put it that way. There wasn't much happening substantively in the legislative tax field. The major law that I can recall was probably in 2011. But between 2019 and now, we've seen how the administration has tried to enact laws. And what are they trying to do? They're trying to basically bring our laws up to speed with business realities. And in doing so, however, it seems as if we're not paying sufficient attention to the national tax policy, because there are some critical points, objectives, guidelines, and etc. enunciated in the national tax policy, which in fact by itself is supposed to be like the manifesto of government, by which investors could predict that, look, based on current law and the tax policy, these are the kind of things I could be expecting. For example, the tax policy says, look, we want to avoid multiplicity of taxes, we want to have a shift towards indirect taxes and so on. But with the things we're saying, it seems as if we're not paying sufficient attention, and some of the initiatives may actually be interpreted to be happening at cross purposes. So at the end of the day, there's also the point of how these changes that are coming on, what are their impact on tax compliance burden? If you look at the paying taxes study, which World Bank and PwC used to do, and they stopped doing it right now, but at least the most current result was 2020, we weren't doing so well. There's so many countries ahead of us in Africa, the Mauritiuses and the Rwandas of this world. So the question is, as we're making these changes, as we're making amendments, how does it impact on our competitiveness as a country? Because tax is also a tool, by which we attract investments. In fact, the preface of the Minister of Finance to the 2017 tax policy said that Nigeria wants to send the right signals about our tax system to local and international investors. At the end of the day, this thing just has to be very critical on our mind in whatever actions we're taking. And at the end of the day, when we look at policy, laws, and administration, it must be that we want to enable businesses, because the better businesses perform, then the more there is for government to share. Thank you very much.
Thank you very much. Thank you very much, Afolabi. I can tell you for free that we're not doing very well in the area of tax certainty as a country, because yes, we have the Finance Act that now comes out every year, which is a good thing. Personally, I was very happy that we now have that, because at least we now know that's one area of certainty. We now know that every year we're to expect some piece of tax legislation, a Finance Act that would update our tax laws. So that is a type of certainty on the one hand that is being achieved. However, the uncertainty that has now created is that with every Finance Act that is promulgated, the FIRS does one thing that they've done for years, which is also a good thing. They come out with explanatory notes. However, increasingly, those explanatory notes sometimes they derogate from what you find in the Finance Act, and almost takes a life. The explanatory note almost takes a life of its own, and is administered and implemented like a piece of legislation. And that's a problem. That's a problem because there's a fundamental principle that you cannot tax except you tax within what the law provides. And so if the law provides clearly and you apply the rule of literal interpretation to that XYZ should be taxed, and it defines what XYZ is. And then you have an explanatory note that tends to expand the scope of that definition, and of course, which then forms the basis of tax administration. You have created uncertainty. So we can now no longer even rely completely on the Finance Act and its provisions, because we do not know what else explanatory notes and information circulars would add to that. So that's another problem that we're going to talk about, and hopefully we can fix. And just to say that often when we have tax administrators in the room, sometimes there's an air of tension, and it's, us versus them. That hopefully that's not what we're going to have this morning. It's not about us versus them. We are all stakeholders. And so as we have the tax authorities here with us, at the end of this panel, the hope and intention is that we can have a conversation that leaves them with solutions that they can take back to the drawing board, and which hopefully we can see reflect in future finance acts that will be promulgated. So thank you very much for that contribution, Falabi. Now I move very quickly to you, Dr. Jude Odin-Konigbo, Jude, as I call you like to. And to talk about the FRS Establishment Act and the amendment that was made by the Finance Act 2021 in relation to the ability of the tax authorities to access records, data, or information stored or otherwise residing in computers or other electronic devices, including magnetic media or cloud computing facilities maintained, operated, controlled, or owned by the individual company or person. And my question to you this morning is, what is the propriety of the provisions of the FRS Establishment Act in this regard?
Thank you. Hello, okay. Thank you, Laura. Yes, you rightly pointed out, and the last speaker just pointed out about on issues of uncertainty or the certainty or otherwise of Nigerian tax legislation. And we know that in 2021, the Finance Act came out, another Section 18 of that Finance Act, 18.1, actually amended Section 24, Section 25 sub 4 of the FRS Act, Establishment Act, by introducing what you may call the ERP, Enterprise Resource Planning, or the use of technology. First, the Enterprise Resource Planning is like a software most companies use to kind of control and centralize information regarding their companies, for instance, human resources, recruitment, finances, supply chains, and everything about them, trademarks, intellectual property, including patent, trademarks, and trade secret, and all that are centralized in one place by these companies. Now, knowing full well that if you look at Section 26 of the FRS Establishment Act or Section 60 of the Company Income Tax Act, there are provisions that empowers the tax authorities to call for returns or books. FRS could write to you, or state tax authority could write to you, please furnish us your certain books, information that could help us determine your tax liability or otherwise. And you have to do that. So, but you find out now currently that everything in the world has gone digital. People do a lot of things using the internet technology, and that's why the ERP, Enterprise Resource Planning, is being used by most companies, the large companies, even medium-sized companies and small companies. So, the Finance Act 2021 by Section 18 amended Section 25, adding Section 4 of it, saying that FIRS could use technology to assess your information, hooking up to the ERP that the company have. And all they need to do is to give you 30-day notice. Please, we want to have access to the information you have in your system. And remember that this information are most of the time centralized. So, and if you don't comply after that 30 days, you have to be paying 25,000 naira per day. Each day you default. Now, globally, OECD has done things on this and other countries. It helps the FIR, because if the information asymmetry is not kind of balanced, the one that have more information is going to kind of, if the taxpayer don't supply the information they have, they could pay less tax, and the tax authorities will know what they have. So the question, to balance it, they want to hook up to your ERP to have information about the information you have, they will have it. But the question now is, how do you strike the balance between enforcing tax enforcement and compliance on one hand, and then the right to privacy?
Because it's not all the information that companies have that this tax authority should have access to. For instance, on the intellectual property, trade secret is not just about formulas. It includes your list of your customers. That's part of trade secret. And there are other issues, maybe your patent formulas and a lot of things that you wouldn't want them to have access to. But once they hook up to that ERP software, they should be able to have access to it. And now, Section 37 of the Constitution provides for right to privacy. So, but that right to privacy is not absolute in itself. You have Section 45, which says that, that right could be limited in any, if there's a law made in a reasonable democratic society. And how reasonable is Section 25(4). How do we balance the right to get tax enforced with the right to privacy of companies? If you hook up to my ERP software, that you have access to all the information, including the plans, everything about the company. Do we draw a line and say, okay, all we need to give the tax authority is just about our earnings, the expenses incurred and all that? And also remember that issues, for instance, in transfer pricing issues, where companies could use their group structure to shift income and all that, that if the tax authority have access to that, you will not be able to hide certain things to them. So the question now, yes, there's the positives, the advantage of having access to information that companies have, especially when you have that ERP that centralizes every information you have. But not all the information there that you need to allow the tax authority to have access to. Otherwise, then that means that Section 37, the right to privacy, means absolutely nothing. So, in effect, we'll be looking at how do we strike the balance. Now, if you look at the Nigerian Data Protection Regulation, it appears to provide that if you require certain information, you have to tell the data subject that this is information you need, and this is the reason why you want it, what you're going to use it for. If you go beyond that, for instance, issues of profiling, tax profiling, by the time you get the information, you say, oh, when you want to do your random audit, you target some companies and some individuals. The answer or the question is unending, and I think we'll throw it to everyone to find out. But for me, I think there should be a balance that should be struck. Not all the information in the ERP structure that should be given access to tax authority. Otherwise, the right to privacy under Section 37 will be absolutely useless. Thank you very much.
Yeah, thank you very much for that contribution. You've touched on some very salient issues. There's a real risk to compromising sensitive information. Yes, in every jurisdiction across the globe, tax authorities have a right to demand for information that they need to ensure that they make proper assessment. However, there are different mitigants that are also in place to manage the real risk that we're talking about here. So in that same Finance Act, there's a provision that any tax official who uses sensitive information of companies wrongly can be prosecuted. We know that that is there, but sometimes the damage that can possibly, the potential damage of this risk may be way beyond what prosecuting a tax official can fix. Now, in terms of management of information generally, if the whole purpose is to prevent the avoidance or evasion of tax, there are other tools that are in place, especially from an international dimension. There are other tools that are in place because when you have a group structure, which is what you have with the MNEs, and that's where the issue of tax avoidance really becomes significant. You have transfer pricing regulations in place, which now include an obligation on the part of the group to file a country-by-country report, which essentially is a report that shows all the operations of the group entities across various jurisdictions. And this is to enable transparency. This is to enable the tax authorities to see what is going on across the different jurisdictions where a particular M&E group has its operations, so that if you're hiding money here, then from that information that you're reporting, we can see the movement of money, we can see the movement of activities within the group. So we have that there. And there are means of processing this information as well that gives the tax authorities the ability to be able to identify where avoidance is taking place. Apart from that, you also have exchange of information tools that are used between different tax authorities across jurisdictions as well. Some of these are automatic. In other words, these are information that are constantly being filed and reported, and tax authorities have access to this information. So what I'm trying to get at is that there are different ways now by which tax authorities can get the information that they need. But coming back to the risk to the company, to a business, of having its trade secrets out there or accessed wrongly, I think that in addition to the data protection rules that we have in place, in order for tax authorities to be able to access certain types of information, perhaps it will be useful to get a court order for the court to first of all even determine whether there is a need beyond the company providing the information that the tax authorities have requested for, whether there's a need now for the tax authorities to go into the ERP of a company. Because there are other things that the company does that are not necessarily related to the issue of profit and loss, which are sensitive to the company. And you never know, corporate espionage is very real. And in a country that is rife with corruption as well, we need to be very careful with how much access is given to trade secrets of companies, all in the name of taxation. So moving on finally to the FRS, before I call on Mr. Ukpai, who is going to touch on all the issues that we have discussed, and then we'll come to the second aspect of our panel discussion, just to commend the FRS in saying that the face of tax administration in Nigeria has really improved, and we would like to see a lot more improvement in various areas. The face of the tax administration is gradually becoming more friendly. But one area that I would like for the tax authorities to look at is understanding the different nuances in business models, particularly as digitalization is advancing. So hopefully in his discourse this morning, Mr. Ukpai would help us to see what tools the tax administration is putting in place to ease tax administration in Nigeria. Mr. Ukpai, you're next.
Yeah, thank you very much, Lolade, especially for commending the FRS on the improvements we have made under the able leadership of Alhaji Mohammed Nami. I want to say that a lot have happened in FRS. Especially it is because of these changes and friendly policies that we were able to collect the sum of 6.4 trillion naira last year, which is the highest ever in the history of the service. So we are really doing much. Well, I think the essence of this gathering is for us to discuss and discuss issues that affect the taxpayer, discuss issues that affect Nigerians, tax-paying public, and then talk about the perception, some of the perception that people have about FRS, which may not be entirely true. Like, I am 100% correct that the FRS have the most current compendium that can give you all the taxes, barely looking at it, and we share with all the consultants that represent companies. Another one is that it's also necessary to point out that Nigeria operates what we call self-assessment filing scheme. And in that self-assessment filing scheme, companies are free to prepare their account the way and manner they want to do it. And we all are Nigerians, we know what obtained here, and that you hardly can find it in any other tax jurisdiction over the world. So if we don't have this, in fact, before this issue of ERP amendment of section 25(4) was done, you have a situation where companies, some of them, let me not say general, will prepare 3 different sets of accounts. And you are there in their premises to review the thing they have prepared themselves under self-assessment scheme. Because when you file, you must be expecting the FRS by way of authority that we are coming to look at what we have done. When you go there to request for it, you will not get anything. So what this thing simply means that we will use all the technology, ICT guys, the experts we have in FRS, we will now have access to get those information. Don't forget that as officials of the FRS, everybody is under what we call oath of secrecy, and that any attempt to divulge information, not just to companies that you are not supposed to divulge, will end you a very serious punishment. Well, coming back to the question, the FRS believe that all taxpayers, they are our king. And because they are our king, we treat them with respect, we appreciate them, we do a lot to make them pay their taxes seamlessly. We call it easier doing business. And that is why we support the various government bodies that prepare Finance Act. We are a stakeholder in the Finance Act. That is to make the law very clear and simple so everybody to understand. Before the Finance Act 2019, it was, you can recall that some of the taxes some of the laws were carrying on were laws that Nigeria inherited from the British people. They were too old. So with the coming into Finance Act, we are making the form of a process of paying tax very simple, because you can now easily find the laws and understand the laws that you are supposed to do that. And above that, we are also going forward into making sure that we have a robust tax policy department that issue clarification circulars and public guidelines to the public each time there is a change in any of our laws. The tax policy is there. They will issue circulars, they will issue guidelines, they will issue public notices so people to understand the changes that have taken place in the Act. And I want to also say that I did hear you say that sometimes we go beyond our means to issue guidelines that is beyond what the law have said. As lawyers, you all know that no matter circulars, no matter how well catch, cannot take the position of the law. The only thing those circulars are meant is to simplify the process by our own understanding to make the taxpaying public find it easier to pay. It does not replace the law. The provision of the law still remains sacrosanct and is there. So again, in FRS, part of the new things we have introduced, Taiwo have said it, but I have mentioned it, to make sure that people find it very easy to pay tax, and for us to join the other world jurisdiction in revenue, we have introduced what we call tax promise solution. With the tax promise, you can stay in the comfort of your room, your bedroom, your offices, to register for tax, file your tax returns, pay your taxes, and even get your tax clearance certificate. So it's so simple. Yes, it's a new technology that we introduced. It may have 1 or 2 teething problems, but it is making progress. And it is when we introduce the technology that we're able to break this record 6.4 trillion revenue that we generated last year. So it's a technology that is working. And above that, the world is driven by automation and technology. We are now doing what we call VAT automation in certain sections of our economy, in retail outlets, restaurants, hotels, and shopping supermarkets. But we are going to automate every other process. As experience have shown that when you automate a particular sector, the VAT that comes in from there sometimes triple. We have situations where a particular organization or company it shows that technology is the way for us. And when we get this observation, again, we should all know that the VAT issue, we are all agents of collection to the government. It's not you that is paying the VAT. If their rules is 100 naira, government said add 7.5% towards that, you are only an agent. The experience shows that many people collect and they don't remit, and it pushes us into the tight corner. We are aware that government need money to carry out a lot of activities. So the automation process is to simplify the process of paying tax and make it for everybody to understand. And with that in mind, it helps us to collect more money and more revenue. And in FIRS again, we have discovered that communication is the key. I will set up what we call contact center as our headquarters. The idea of the contact center is that whenever you are, you can call the contact center and ask questions on any aspect of your taxation. That's what the Nigerian administration have done. And it is broken down to various key Nigerian languages, whether it is Hausa, Yoruba, Igbo, and many other languages, all broken, which is a means of communication by most small tribes and big tribes in Nigeria. So if you call the contact center 24 hours, and if there are people questions that the officers that are working in the contact center cannot answer, there are experts that are standing behind. Some of us, when you ask questions and they cannot answer, they will cascade that question to the experts. So all this is geared at ensuring that taxpayers get the right information that they need to pay their taxes and remove the bureaucracy and the cap that the will have in the past. So the contact center works. It's a technology and innovation that is making us to collect more money. And again, we are collaborating with a lot of agencies to get information. In the past, information about taxpayers was very difficult. Now we are collaborating with EFCC, NSIU, ICPC, Interpol, because all these people again demand information from us about the activities of the taxpayers. And also, we don't forget even the Nigerian police. We get from custom, and we also exchange information with custom. With this information at our disposal, it has helped the revenue to reduce the tension between them and the taxpayer because we will not get information about the taxpayer public and to and to make sure that we sensitize the taxpayer public. We engage the stakeholders, major stakeholders. Chief Taiwo is here, the tax consultants, made up of lawyers, accountants, both those in ICANN, those in CITN, those in ANA. We engage them when any new development comes about. We call them together even before we implement any major changes in the tax law, like the PIA. They only did for yesterday in Lagos. All of us were in the hotel with all the consultants, all the stakeholders, discussing the new PIA that had not been introduced. The idea is to make sure that we're on the same course, that we work together, we collaborate with each other, we don't create any vacuum that will bring the argument, false argument, that is the whole thing. That's even what we do in most time when we have meetings like that, we discuss it and expose it to everybody that needs to know. And to you all lawyers that are here, all of us, FRS have in its employment several lawyers, and we pay their annual practicing fees. And we pay most of them, that's valid. We send most of them to the annual NBA conference. We send most of them to Africa Bar Conference. And we send most of them to International Bar Conference. So the idea is to let them be at par with their colleagues on the most recent development on the legal profession. That's what we do. Even though we also extend the same thing to other professional bodies that are in employment. So we train our staff, and we don't just restrict our lawyers to just doing the legal aspect of it. We change some of them to professional tax people, and we utilize them not just in the legal department. We have lawyers in every department in FRA. That shows that we are giving them enough training. That shows that we're supporting the legal profession. That shows that we're not going to see them to go into court and do that. So they work with us and so in FRS, we have done a lot and we continue to do a lot and continue to listen. We are not about to make changes. If we get any suggestion, explanation that we think we can get back and review and get back to them. But don't forget that we are not the one that make the law. We only support them. So we are even aside the lawyers, we are supporting the judiciary in too many areas of training. So thank you very much, Moderator. God bless you.
You're unbelievable. Two questions. We'll take one live on the spot. Yes. Question and answer. Mike. Do you have the question? The person to ask the question. I can see three hands. Sorry, the lady behind you, I hand the buffer. I'll take you. Yes. Go to the front. Thank you. My name is Ichime Okuno. I have two questions for the parents. But two questions, very short questions. One is answer and third question on Afromax and the fact that they help activate your self-assessment. And the second question is on tax credit. We haven't spoken about it, but I know that it's not a recent development, it's still something that's ongoing in the business community. And we have clients who come to work and say we have so much tax credit and they're able to collect it or the process is, I don't know what the FRS is. I know there's a process, but you help it.
Yeah, thank you very much. Well, I was even going to talk about the tax credit. Even there other main credit that the FIA do in the area of production of infrastructure. When we said any company that can construct roads, build bridges, do dam, we can give you credits which you use to pay your taxes. Of course, that's why you're enjoying the Lagos and Secondary roads that is done by Dangote, is sponsored by way of tax credits. And then LNG is constructing Okobo body channel to link Port Harcourt to Bonny Island, and all was done by tax credit. Well, what we are talking about on tax credit is, is the word they are talking about credit is right from the withholding tax process we have. If you do a contract of 100 million, and then the withholding tax credit on this, let's say, is 5%, that means that you will be, the person that gave you the job will pay you 95 naira, and deduct 5 million and ready to FRS. And that 5 million will call it advance payment of tax, that you can use it and pay your tax. That's why you have a credit. But when we introduced tax program in 2020, we needed to have a cutoff. And that cutoff was 1st June 2020. But we had legacy credit loan that people had been keeping with them. Some of them over 15 years, over 20 years, over 10 years. They were supposed to have used this credit note until being able to have paid their tax, their family accountants, and they did not. So now that we have cut off from that 1st June 2020, means that every transaction will be done that suffered withholding tax automatically it will be credited into your account. Take card in class. So the other ones will say that okay, you need to come and bring them up to us, and they will do a review. The review we are going to do simply will show that the 95 naira you collected when we deducted 5 million, 5 naira from you, that you have accounted it in your previous financial statement, so that you don't take double. If you didn't report the tax on the 95 naira and you didn't pay any other tax on it, and you are coming to collect 5 naira, so we only check it that you have actually accounted for the main money you collected. And once you do that, the credit will be uploaded in that format. So it's not something that will not deny anybody their rights, but that will also use that payment. Before we give you that credit, for those legacy credit that you have, we need to review. That's what we do. Thank you.
Yeah. Give me a spot here. A spot? No, it's too far. Let me use it. You can remove this laptop. So I'm just trying this laptop.
Let me take this one. What is the current position? See what is it? What is the current position on taxation of intellectual property?
Okay, thank you very much. I think we first on the task program and self-assessment. My view on it is that if you put in your information and the system calculates your tax, it should only be a recommendation. So you should be able to ignore it. There's no one that amounts to calculate for me. this is the amount that I want to pay, and then it will ask you to explain why you disagree. So that becomes intelligence to FRS to work with. Because I know of companies that said the police levy, the police trust fund levy was declared unconstitutional, and they don't want to pay, but tax programs forces them to pay because without paying they can't continue the process. On intellectual property, there is no special tax law as to how to tax intellectual property. So it will depend on the nature of the transaction. If, for example, if you transfer your IP to another person, it might be a capital gains tax issue you are dealing with. Whereas if you exploit it, it could be a question about royalty, where you pay withholding tax. It could be a question of CIT, where you pay company income tax and the withholding tax and advance payment. But I think what is right to say is that it's not treated in any special way. It may not be as common as buying and selling goods, but it's clearly liable to tax under different forms depending on the nature of the transaction. Thank you.
Ladies and gentlemen, our time is fast spent, but I can see even from the questions here that a lot of people are concerned that a lot of the tax money that is being collected is not being seen in the state of the economy. And I had hoped we would have an off-script conversation. I will still be audacious and just use our last few minutes to talk about how, I mean, Papa, you're a legal practitioner as well. And the simple question is, how can we as lawyers get more involved in the making of tax policy? Because we talk about stakeholder engagement, a lot of that is really done after the fact. How can we get more involved? Because we can see how foreign direct investment is being eroded. And I personally worry that in another 2-3 years, we actually have nothing to tax. So please advise us here as a body of lawyers on how we can get better involved, more involved, before our tax laws actually come out in print. And then we close the session.
Yeah, thank you very much. Before any tax law is passed, there are various stages